So all of the attention continues to be on two things, tariffs and these judges. And joining us now to talk about these judges is Michael O'Neill. He's Vice President of Legal Affairs at the Landmark Legal Foundation. Michael, thanks for joining us here on the Chris DeGaulle Show. Bob France in. How are you?
I'm doing well, Bob. It's great to be with you.
It's good to have you too. There's so many things that are happening right now. When I ask your opinion on the tyrannical judges trying to substitute their judgment for that of the President of the United States and by extension of the American people, but there are three particular cases we have seen some resolutions to, or at least advancing toward resolutions in the last couple of days, and I want to ask your thoughts on those. First one is freedom of speech related.
Sure.
The AP was booted from the press briefing room because they refused to call the Gulf of America the Gulf of America. A judge now says, or was this the Supreme Court actually, that said they get to be in the room, at least for now. Can you lay that out for us?
I think this was the case I think the allegation was that the White House was engaging in viewpoint discrimination, and that they were specifically saying because the the Associated Press wasn't adopting a certain position, that it was going to be barred from access to the Oval Office and to Air Force One, as I seem to recall. And the Associated Press alleged that this was a form of viewpoint discrimination in violation of its First Amendment rights. We do know that the right of free press is one of the highest rights that we have under our Constitution. The right to free speech is one of our most important rights, and that courts are always going to be very skeptical of government action that can be interpreted as infringing upon the right to free speech. You have the Associated Press, which is, again, we can talk about the effectiveness of the Associated Press, but traditionally this is one of the premier news organizations in our country, probably not so much in the past few years, but this is an organization that has a long history with access. And so courts are going to be amenable and are going to be particularly sensitive to any allegations that there might be a violation of their First Amendment freedom of press and freedom of speech rights. And it appeared that this was the case in this situation with this judge.
Yeah, and the frustrating thing about it for me, from a conservative point of view, is consistency. I want consistency. Yeah. Basically, what the court said is here is the White House is engaged in viewpoint bias. Well, that's because the AP is engaged in viewpoint bias every single day, and
right.
They make it very, very clear on which side they are. And and if you're talking about a time in which there is a lot of new competition for the traditional legacy news sources, if they want to give more attention to those that are willing to hear all sides and not just continue to engage in their own biased, viewpoint journalism, I can understand why the administration wanted to do that.
I can as well. And you want to say, on one hand, you think that the White House has this is access to the Oval Office and to Air Force One. So this is a privilege. I would specify that this is a privilege here. This is not. You don't necessarily have a right to access to those particular rooms. Clearly, you have a right to question the president, to engage in colloquies, to have access to the press room, all of that traditional notions. But I think here what we're talking about was access to the White House and the Oval Office. But again, as I go back to it, you're going to have courts, and I think that's what I'm asking for too, Bob, is a fair playing field here. If courts are going to be, if courts look at this equally, they give conservative news media outlets just as much access as liberal news media outlets. And I'll assert to you, people will argue with this, but I'll assert to you that the AP doesn't make any really effort to be objective journalism anymore. They've gone far left. But what I'm asking for, and I think what you're really highlighting, is the need for a fair and even playing field. If you're gonna engage in viewpoint discrimination, you engage in viewpoint discrimination, and that's wrong at every level, whether it be conservatives or liberals. I'm a First Amendment purist here. I believe in freedom of speech. I believe in equal access as well.
Yeah, and I do too. I'm a First Amendment supporter as well, almost in every circumstance. But again, I am also a believer in consistency and fairness, and
Absolutely.
I think it needs to be applied in all ways. We're talking to Michael O'Neill, Vice President of Legal Affairs at the Landmark Legal Foundation. We also found out that the president and the administration does have the right to fire federal employees. Yeah. Tell us about this.
This is a good case. This is a case where a number of public interest groups representing fired, terminated, probationary, and I think it was temporary federal workers or probationary federal workers, it was about 11,000 of them, had brought a lawsuit alleging that the president didn't have the authority to terminate their employment status. Well, as I understand, and I hold to the fact that the president is the chief executive of the United States, and the executive office, the executive power is vested within the president of the United States. Therefore, he has the authority under our constitutional system to terminate federal employees within his department, within his branch. This is almost an offshoot of the unitary executive theory. And I think the president, he didn't make any bones about what he was going to do. He was going to clean house, and he was going to do this in an effort to get our fiscal house in order. He's identified redundancies in the government. He's identified individuals who are not really doing their jobs. DOJ has been doing a lot of good work identifying federal workers who are not even showing up for their jobs, or in instances where they might be holding multiple jobs, instances where they haven't checked into the office in weeks or even months. So I think the president was acting well within his authority to terminate these employees. Of course, the Supreme Court here ruled that the standing necessity, the standing issue wasn't satisfied. The organizations that brought these lawsuits didn't have standing to bring the lawsuits. So technically, the court threw this out on a technicality, a standing technicality. But those technicalities are important when you're bringing these lawsuits.
Yeah, well, they are, and I hate that, by the way. I hate things, technicalities. I would like just for it to be said that, look, the president and the administration can decide what federal positions need to be filled and which ones don't. Because, Michael, the thing that a lot of people don't talk about, the one economic hook on which the Biden administration had to hang their hat was job creation. They couldn't talk about GDP. They couldn't talk about inflation. They raised it to 9%. We struggled with it for all 4 years, but they were always talking about, look how many jobs are created, more than anybody else. One, they came back from COVID. Number two, they created a whole bunch of make-work jobs at the federal level. These weren't organic hirings in the private sector. These were, public jobs created for the purpose of saying, look how many jobs we created. So here comes Trump and DOJ saying, yeah, those people aren't going to be around anymore. Those are not necessary. It's just bloated government crushing the American taxpayer. He has to have the right to be able to make that decision free of some activist judge, right?
Absolutely, and again, this was a technical issue on standing. That's important, but I think we are getting to the theory, and there are lawsuits and there are cases that are migrating through the courts, and eventually the Supreme Court is going to come down on this issue and directly address this issue. And I think there is a significant majority. I want to say at least 5 justices, maybe 6 justices, who are going to agree with that point that you're just making, that the executive authority is vested within the President of the United States. He, along with the Vice President, are actually the only executive officers in our country that are elected by the entire country. And so he has the authority to do exactly what the President is doing with regards to terminating federal employees.
And now, Michael, let's talk about the biggest one in the room at the moment. And this is, of course, the Alien Enemies Act, 1798. We all know what happened. We all know President Trump invoked it, used it to ship a whole bunch of really, really bad gangbangers out to El Salvador. And Judge Boasberg said, turn those planes around. Supreme Court said, not so fast. The president can do this, at least for now. It was a 5-4 ruling. What's your read?
It was a close ruling. The court thankfully vacated this temporary restraining order that was instituted by this district court judge in Washington, D.C., who essentially, as you said, had halted what I consider a national security operation. You refer to them as gang members, and I understand that, but I really refer to them as narco-terrorists. And I think when you think in the context of the fact that this is a national security operation, this is, again, the president is operating in his role as commander-in-chief, protecting the national security interests of the American people. He has identified several hundred, and we're just talking several hundred individuals here who represent a clear and present danger to the American people. These are the worst of the worst individuals. And he instituted a power under the Alien Enemies Act to identify, detain, and remove these individuals on an expedited basis. Of course, these lawsuits were brought in a district where there was most likely going to have a favorable judge to the position of that President Trump was acting ultra vires or outside his authority. But the court said, look, jurisdiction is not proper in Washington, D.C. Venue lies in the district of confinement. And that's the wording from the Supreme Court here, essentially saying that if you're going to bring a challenge to any of these actions, you have to, number one, bring them in the district where they are confined, and that means Texas or Louisiana. And number two, you have to bring them in a habeas proceeding. You can't bring them in this class action kind of lawsuit effort that they've been brought previously. So what does a habeas proceeding mean? Habeas proceeding means that these individuals are going to have the burden of bringing their case in front of a district court judge, again, down in Texas or Louisiana, and the burden is on them to say, hey, I'm not a member of Tren de Aragua. The burden is on them, not on the government here to say you are a member. So they have to prove why they have been unlawfully detained. So this is a good win. The fact that it got out, the fact that it was no longer in Washington, D.C. is a win for the Trump administration and a win for the American people, I'd submit to you. And then number two, the fact that this judge is temporary restraining order, again, acting well outside the scope of his authority, has been vacated, is another win for us, everyone.
Well, and of course, that is what everybody is discussing here, is whether or not district court judges can issue rulings that impact outside of their district, the entire country. And you know, I'm a layman. I'm not a lawyer like you, but I mean, it stands to reason that one individual district court judge should not have the same exact power as 5 Supreme Court justices do. And it takes a 5-4 majority at the minimum for something to have a nationwide impact, a ruling by the Supreme Court. Why can one judge like James Boasberg, or anybody else for that matter, have the same power to impact the entire country in the way things are done that the Supreme Court does?
And they shouldn't have that power. And you said it exactly right. I don't think this was ever envisioned by our framers. Can you imagine that these are courts, again, under the Constitution, these are inferior courts established by Congress. The framers or the founders never envisioned a situation where you would have a lone district court judge being able to institute nationwide policy affecting, you're talking hundreds of millions of Americans. And that was never envisioned. And I think you're seeing, for the first effort here is the court, I'm going to look for the appellate courts and the United States Supreme Court to kind of keep their own house in order, get their house in order. And I think this step here where the TRO was vacated in this Tren de Aragua case is really a pushback saying, look, take note, federal judges, you don't have this unilateral authority to impose these nationwide injunctions. And if you don't and if the Supreme Court and the district courts and the circuit courts don't get their house in order, what's going to happen is Congress is going to step in here. Now, remember, Congress has authority, as we just said. Congress has the constitutional authority to pass laws that would limit the jurisdiction. There's been some movement on that in Congress. They do have supervisory authority and some sort of authority over the federal courts, the inferior courts, as Congress does establish.
Michael, I'm out of time here. I appreciate it. Thanks very much for your time. And it's probably going to end up coming down to the Supreme Court because Congress isn't going to get there in time.
For full shows, live and on demand, it's Salem News Channel.